Putting to rest all theories on the outcome of the 18th Amendment case, the Supreme Court has sent the objections to changes in the system of judges' appointment to Parliament. Reserving verdict on September 30th, after hearing the pleas against the 18th Amendment for over 4 months, the Supreme Court was to announce a detailed judgment. Instead, it came out with what constitutionalists believe is an interim order.
Well, you may call it an interim order, you may call it an interim judgment, but as I said that Supreme Court was probably inclined to believe that in case Parliament was requested to reconsider, Parliament would reconsider, and that would be a much better step.
Some lawyers believe the court did not rule against the amendment because of the supremacy of the Parliament.
The Constitution gave power to the Parliament to make amendment by the only condition two-third majority. If they have two-third majority, they can make any sort of amendment. They are the best judges, they are the elected people, they know the wisdom of the people.
Others believe the court could not even make a direction to the Parliament.
Well, we accept the independence of the judiciary within the parameters of the Constitution. And as I said, Article 189 and 190 are very clear. The legislature cannot be directed, you know that.
Until the Parliament decides on the court ruling, the judges shall be appointed on the basis of the new amendment as well as the order of the Supreme Court.
So all further appointments and also the confirmations of the additional judges of the High Courts will now happen in accordance with 175A, but subject to the observations made by the Supreme Court. Now those observations are that the Parliamentary Committee will give good reasons and so on.
On one hand, the court had required the Parliament to rethink the amendment, and on the other, it laid down certain parameters for the appointments to be made. The petitioners feel the court could have been more categorical.
4 months of solid arguments and time of the court were used up, and it would have been better if a categoric decision had come one way or the other. But I believe that there was some gesture from Parliament, or directly or indirectly.
The court is to weigh the amendment once more in January after the Parliament decides its fate with or without the guidelines of the Apex Court. Faisal Shakil, Express 24/7, Islamabad.